I want to talk today about a relatively new concept that criminal defense attorneys are coming across right now. It's the idea of smell plus. And you might be asking yourself, what does that mean? What's smell plus? In fact, there's been a couple articles recently written about smell plus, including the New York Times and even in the Palm Beach Post. The concept is prior to the enactment of the Hemp Bill 581.217 Florida statutes, an officer only needed the smell of marijuana to justify a search of a vehicle. Now, since the passage of the Hemp Bill, the prosecutors across the state are realizing that they may come into a problem if they try to prosecute all cases where marijuana is found in a vehicle where the officer only suspected marijuana was used because of the smell. So what smell plus is, and what it means essentially, is that an officer has to have more than the odor of marijuana to suspect that a crime is occurring. So they need something else. So something else might be some paraphernalia in the car. Something else may be furtive movements, nervousness by a defendant or a suspect. Those are some additional things as well. But the concept really has come down to is, does an officer have enough reasonable suspicion to search a vehicle when they only smell marijuana? And prior to the enactment of the Hemp Bill, that's all that they needed. I do want to take a step back and explain why that is. Prior to the enactment of the Hemp Bill and prior to the legalization of medical marijuana, it was illegal to possess marijuana in any form. So the odor of marijuana, which has its own distinct odor, was enough for an officer to justify a search of a vehicle to indeed find marijuana, and that's been upheld by several courts. When medical marijuana came about, several attorneys, including myself, started filing motions to suppress based on the fact of, again, arguing smell is not enough because medical marijuana is a legal product. And when the state started allowing what they call flower marijuana, or the raw marijuana, that would have taken the justification out. But on July 1st, 2019, when the passage of the Hemp Bill came out, because it's been scientifically determined that it would be difficult for anybody to determine the difference in smell between hemp and marijuana with active THC, that basically we would be running into prosecutorial issues on every case where the only basis for the search is smell. Plus, it would also then require the state to have to test every piece of what the suspect marijuana, which could be hemp, in every case, and they don't have the resources. So what we're seeing right now is the state not pursuing a lot of these charges based on just the odor of marijuana. So if you have a smell plus type scenario in your arrest, it's important that you get good legal representation to understand if your Fourth Amendment rights have been violated. If you want to learn more about this and other legal issues, go to my website 561law.com and read more.